Before most Americans even woke up this morning, the Supreme Court quietly changed how power works in the United States. No warning, no public debate, no televised arguments. Just a sudden 6-3 emergency ruling that began affecting millions of people the moment the digital ink dried. And here's the part almost no one is telling you yet. This decision in Trump versus Cassa Inc. isn't just about a single executive order. It doesn't just resolve a narrow legal dispute. It fundamentally changes how your rights are protected in this country. Whether you realize it or not, the legal ground beneath your feet just shifted overnight. This isn't just another Supreme Court headline. This is a tectonic realignment of power between judges, the president, and you. In state capitals, federal agencies, and courtrooms from Washington, D.C. to California, the rules of the game were rewritten in a matter of hours, and most people have no idea what just happened. Before we break down the details that are already sending shockwaves through the legal system, make sure you're subscribed. This is exactly the kind of Supreme Court decision that doesn't feel real until it hits your life directly. Late last night, the Supreme Court released a 6-3 emergency ruling in the case of Trump versus Cassa Inc. They did this through what's known as the shadow docket. That means no months of public deliberation, no oral arguments on the merits, just a rapid, high-stakes decision that immediately reshapes the legal landscape. The shadow docket wasn't always this powerful. Historically, it was reserved for truly urgent matters, execution stays, genuine emergencies where delay would cause irreparable harm. But over the past few years, it's evolved into something else entirely. A fast-track system for major policy decisions that would traditionally take months or years of careful deliberation. The case itself was a firestorm, an executive order involving birthright citizenship, one of the most controversial legal topics in American history. 3 separate federal judges had issued nationwide injunctions blocking the policy from taking effect anywhere in the United States. But the court used this case to do something much, much bigger. They settled a decades-long internal war over judicial power. At the center of this ruling is a concept most Americans have never heard of but have relied on for decades: nationwide injunctions. The Supreme Court just ruled that federal judges can no longer issue universal injunctions that block a law or policy from being enforced across the entire country. While that may sound like technical legal jargon, the consequences are enormous. This single decision rewrites how constitutional challenges work in America. For the last quarter century, when someone challenged a law they believed was unconstitutional, a single federal judge could temporarily stop that law from being enforced anywhere in the United States while the case worked its way through the courts. One judge, one courtroom, one order, and the entire federal government had to hit pause nationwide. Think about the power that gave a single person. That power was used in immigration cases, healthcare disputes, environmental regulations, gun laws, and voting procedures. A judge in California could freeze a policy in Texas. A judge in Texas could block a rule from taking effect in New York. That power shaped battles over immigration enforcement, healthcare mandates, environmental regulations, gun restrictions, workplace protections, and voting procedures. Advocacy groups on both sides of every major issue relied on this tool as their most powerful legal weapon. That era is now over. The Supreme Court didn't just limit that power, they effectively dismantled it, and the timing couldn't be more explosive. According to court filings reviewed this morning, there are currently 68 active nationwide injunctions affecting everything from prescription drug access to workplace safety and election administration. Under this new framework, many of those injunctions could collapse within the next 60 to 90 days as lower courts scramble to revise their orders. We are heading straight into an election cycle with major fights over immigration, civil rights, and voting rules. This ruling just changed how every single one of those battles will be fought. The majority opinion was written by Justice Amy Coney Barrett. She was joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their argument rests on a simple but radical claim. The Judiciary Act of 1789 never gave judges the authority to protect people who aren't actually part of the lawsuit. According to the majority, a judge's role is to resolve specific disputes between specific people, not to act as a nationwide veto over presidential action. If you didn't file the lawsuit, the court says, you don't get the protection of the court's order. But the most explosive reasoning didn't come from the main opinion. It came from Justice Gorsuch's concurrence. He traced court practice from the founding era through the late 1800s and found something he calls remarkable. He argues that American courts never used to issue injunctions protecting people who were not directly involved in the case. Judges repeatedly refused to extend relief beyond the actual plaintiff standing in front of them. Time and again, judges limited their relief to the specific individuals who filed suit. Justice Thomas went even further, arguing that nationwide injunctions are a modern invention that encourages forum shopping, where advocacy groups hunt for sympathetic judges to shut down policies they oppose. This is the practice where advocacy organizations hunt for the most sympathetic judge in the country to shut down a president they don't like. Under Obama, conservative states shopped for judges in Texas to block DACA. Under Trump, liberal states shopped for judges in Hawaii or California to block the travel ban. According to the 6-3 majority, that era of judicial activism is officially dead. The dissenting justices, Sotomayor, Kagan, and Jackson, saw this very differently. Led by Justice Sotomayor, they warned that stripping courts of universal relief gives the executive branch the ability to enforce unconstitutional policies while individual lawsuits crawl through the system. They argued this ruling risks turning constitutional rights into privileges reserved only for those who can afford to sue. If the government passes an illegal rule, and you aren't the one with the lawyer in the room, the government can still enforce that rule against you, even if a judge has already called it illegal in someone else's case. Justice Jackson went so far as to call this an existential threat to the rule of law, warning that the decision creates enforcement zones where the Constitution effectively doesn't apply unless you personally have the resources and legal standing to challenge it. Her dissent painted a troubling picture: vulnerable populations facing government overreach, but unable to afford the legal fees required to challenge it in court. Meanwhile, the policy they're challenging continues unabated everywhere except in the specific jurisdiction where someone successfully sued. Within 48 hours of this ruling, the legal landscape shifted dramatically. The speed and scale of the reaction tells you everything. Attorneys general from 18 states have already filed emergency motions. Some are trying to save their protections. Others are moving to immediately enforce laws that have been frozen for years. Texas moved aggressively to narrow injunctions that had blocked aggressive immigration enforcement tactics. Florida filed emergency briefs targeting social media content moderation rules and election procedures that had been on hold. California and New York countered with their own filings, desperately trying to preserve nationwide blocks on federal policies they oppose. Behind the scenes, the Department of Justice convened emergency strategy sessions with hundreds of federal attorneys across dozens of active cases. The White House counsel's office quietly warned federal agencies to prepare for laws they believed were blocked to suddenly take effect, possibly within weeks. Why the panic? Because for the last 25 years, the nationwide injunction was the emergency brake of the American legal system. If the government tried to do something a judge found illegal, that judge pulled the brake and the whole train stopped. Now that brake has been cut. The train is still moving, and in some states it's picking up speed. Let's talk about the specific case that broke the system. Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. This order aims to reinterpret the 14th Amendment to deny automatic citizenship to children born on U.S. soil if their parents are unlawfully present or here on temporary visas. Under the old rules, a single judge in Maryland or California could block this order for the whole country while we debated if it was actually constitutional. And that's exactly what happened initially. But the Supreme Court's 6-3 ruling didn't say the order was legal. It just said the injunction was too broad. Here is the nightmare scenario. Because the nationwide block is gone, the executive order is now scheduled to take effect in just 30 days. But because of how party-specific relief works, it might be blocked for the specific families who sued in Maryland, but fully enforced against a family in Florida who didn't. We are potentially entering an era where a baby born in a hospital in San Diego is a U.S. citizen, but a baby born the same hour in El Paso, under the exact same legal circumstances, is not. This isn't just a legal patchwork, it's a fragmentation of the very definition of an American. This is where the ruling becomes deeply personal. It creates what critics are calling zip code justice. Think about the issues that affect your daily life. There are currently 19 nationwide injunctions limiting ICE detention practices, deportation procedures, and border enforcement tactics. Under the new framework, those protections may only apply to the specific plaintiffs who sued in specific judicial districts. Immigration enforcement could now look completely different depending on your zip code. Healthcare is another critical area. There are active lawsuits over prescription drug access and preventative care. Under this ruling, a court might rule that a health insurance requirement is illegal for a company in New York, but perfectly mandatory for a company in Georgia. Environmental rules face the same fragmentation. A factory in Ohio might be allowed to emit a certain chemical because they won a local court case, while a factory in Michigan, owned by the same company, is barred from doing the same. Gun rights could become geographically fragmented in unprecedented ways. Your right to carry or own a specific firearm could literally vanish the moment you cross a state line, not because of state law, but because of which federal circuit court's protection you are currently standing in. Your rights are no longer a blanket that covers the country, they are a series of small umbrellas. If you aren't standing directly under one, you're getting wet. It's not just civil rights groups who are sounding the alarm. Corporate America is in a full-blown panic. Multi-state companies, banks, tech giants, pharmaceutical firms, Rely on regulatory certainty. They need to know that the federal rules for overtime pay or data privacy are the same in Seattle as they are in Miami. But legal strategists are now warning that litigation costs for major firms could skyrocket 5 to 8 times. Why? Because instead of filing one lawsuit to challenge a federal rule, they now have to file in dozens of jurisdictions. Take the banking industry. Financial institutions operate across all 50 states under a unified framework of federal regulations. But what happens when a federal banking rule is challenged and blocked in the Ninth Circuit but upheld in the Fifth Circuit? Do banks maintain two different compliance systems? Do they adopt the more restrictive standard nationwide to avoid risk? Or do they operate differently in different regions? The pharmaceutical industry faces even more acute problems. Drug approval processes, pricing regulations, and distribution rules are all governed by federal agencies. If those regulations can be enforced differently in different circuits, pharmaceutical companies could face a compliance nightmare that affects everything from manufacturing to marketing to patient access. Technology companies are already wargaming scenarios. Social media content moderation rules, data privacy requirements, and antitrust enforcement could all become geographically fragmented. Estimates suggest this legal fragmentation could cost American businesses tens of billions of dollars annually in compliance costs alone. Imagine a bank trying to manage 50 different versions of a federal lending law because injunctions are being granted and denied in a patchwork across the map. It's a regulatory nightmare that shifts the advantage entirely to the executive branch. When the same federal environmental rule applies differently in different circuits, how do you build a national compliance strategy? The answer increasingly is that you can't. You build 50 different strategies and hope for the best. Now, to be fair, the 6-3 majority says this chaos is actually a return to order. The majority argues that by ending forum shopping, they are forcing the law to develop naturally. They want different courts to come to different conclusions so the Supreme Court can eventually see all the arguments before making a final decision. They call it percolation. But the dissent asks, what happens to the people who are crushed while the law percolates? By stripping the courts of the power to issue nationwide blocks, the Supreme Court has effectively handed the president a zone of lawlessness. If a president issues an order that is clearly unconstitutional, they can now enforce it against 99% of the population, while the specific plaintiffs in a lawsuit spend years fighting it out in court. As Justice Sotomayor pointed out, this gives the government the ability to outrun the justice system. They can implement a policy, achieve their goals, and by the time a court finally issues a final ruling years later, the damage is already done. For decades, we lived in an era of automatic protection. If the government overstepped, a single lawsuit could protect everyone. You didn't have to know a lawyer, you didn't have to follow the news, you didn't have to spend a dime. The nationwide injunction was the shield that guarded the public. Today, that shield has been replaced by an opt-in system. If you want your rights protected, you have to sue for them personally. You have to find a lawyer who can navigate the most complex legal landscape in a generation. You have to be party A in case B. If you don't have the resources to do that, the government can enforce policies against you that a judge has already called plainly unlawful in another case. As the dissenters pointed out, this turns constitutional guarantees into privileges for the wealthy and the well-connected. The practical effect could be a two-tiered system of constitutional protection. Those with resources, major corporations, well-funded advocacy groups, wealthy individuals, can afford to file multiple lawsuits in multiple jurisdictions. Everyone else gets whatever protection those lawsuits happen to provide, and only if they happen to live in the right place. The majority opinion points to a different path: class action lawsuits. They argue that if you want nationwide relief, you have to go through the rigorous process of certifying a class. This sounds like a reasonable compromise, but in reality, it's a massive hurdle. Class actions take months, sometimes years, to certify. They require astronomical amounts of data and legal maneuvering. While that class action works its way through the system, the executive order is already in effect. In the case of birthright citizenship, by the time a class is certified, how many children will have already been denied documentation? How many families will have already been uprooted? This creates a high-stakes arms race. On one side, you have the executive branch moving at the speed of light to implement policies. On the other, you have civil rights groups frantically trying to certify classes before the damage becomes irreversible. It is a race where the government starts with a massive lead. Some advocacy groups are already pivoting to this strategy. Within days of the ruling, at least 3 new class action challenges to federal policies were filed. But whether courts will allow these cases to proceed as true nationwide classes remains an open question. As we move toward the 2026 election cycle, election administrators are already warning of a nightmare scenario. We are looking at a world where voting rules vary not just by state law, but by court geography. Imagine a federal rule regarding mail-in ballots or voter registration. In the past, if that rule was found to be illegal, it was stopped everywhere. Now we face a scenario where a judge in Michigan blocks the rule for Michigan voters, a judge in Florida refuses to block it, and a judge in Pennsylvania blocks it only for the specific people who filed the suit. We are looking at an election where the very rules of democracy are geographically fragmented. Election administrators are warning that the outcome of a national election could hinge on which specific zip codes were granted an injunction and which ones were not. What happens when voter registration databases are subject to different federal oversight in different circuits? What happens when mail-in ballot procedures are challenged and blocked in some jurisdictions but not others? The potential for confusion and for allegations of unfairness is staggering. By using the shadow docket, the emergency application process, the Supreme Court made this massive change without a full trial, without months of public oral arguments, and without a final ruling on whether the birthright citizenship order itself is even constitutional. The court didn't have to decide if the president was right about the 14th Amendment, they just had to decide that the judges who tried to stop him were wrong about their own power. By doing this, the 6-3 majority is asserting total control over the lower courts. They are sending a clear message to every federal judge in America. If you try to block the executive branch on a national scale, we will reverse you overnight. This creates a chilling effect. Judges who see a clear violation of the law may now hesitate to issue a block, fearing a swift and public rebuke from the Supreme Court. The numbers tell the story. In 2025 alone, the Supreme Court ruled on more than 20 emergency applications from the Trump administration. The administration won the vast majority of them. This isn't judicial review in the traditional sense, it's real-time policy-making by emergency order. When the Supreme Court issues a major ruling after full briefing and oral argument, lower courts and lawyers get detailed reasoning they can apply to future cases. But shadow docket orders often come with minimal explanation, sometimes just a single paragraph. That leaves everyone guessing about what the law actually means. And when lower court judges are unsure exactly what standard to apply, they tend to err on the side of caution, which often means deferring to the government. For civil rights advocates, the implications are profound. For decades, broad injunctions were the primary tool used to dismantle systemic discrimination. School desegregation, voting rights protections, disability accommodations, all advanced through broad court orders that protected entire classes of people. The landmark cases of the civil rights era, Brown versus Board of Education, for example, resulted in relief that extended far beyond the individual plaintiffs. The court ordered desegregation not just for the specific children who sued, but for all students. Under the new framework announced in Trump versus Cassa, it's unclear whether such sweeping remedies would still be permissible. The Supreme Court's emergency ruling in Trump versus Cassa Inc. didn't just change a legal procedure, it changed the meaning of protection in America. If your right to equal protection or due process only exists if you personally have the resources to sue, then those rights are no longer guarantees. They are more like subscription services, available only to those who can pay the entry fee. We are entering a new era of American law, where your constitutional protections may now depend on your address. Whether this represents a return to constitutional originalism, as Justice Gorsuch argues, or a dangerous fragmentation of justice, as Justice Jackson warns, depends on where you stand. But one thing is certain, the legal patchwork is here. Its consequences will define immigration, elections, and your own personal rights for years to come. If you want to stay ahead of these changes because they are moving faster than the evening news can keep up with, make sure you're subscribed and hit the like button to help this information reach more people. And I want to hear from you in the comments. This is a fundamental question for our time. Was the Supreme Court right to end the nationwide injunction to prevent judge shopping, or did they just fracture the rule of law and leave millions of people unprotected? Your answer may say more about the future of America than you think.